today. I greeted you because you were leading last time.
Good morning, Chair.
Yes.
That is correct. I was leading last time.
Yes.
But for today's purposes, Counsel, Advocate Mogotsi, she's the one who's going to be leading.
Thank you.
Morning, Chair. Morning, Co-Commissioners.
Good morning.
It's Mogotsi.
Yes, Commissioner, it's Mogotsi.
Please spell it for me. I just want to...
Surname, Chair, it's M-O.
Just...
H-O.
Thank you. Are you ready, Ms. Mogotsi?
Yes, Chair, we are ready to proceed.
Yes.
Chair, prior to starting, I thought it would be prudent to inform the Commission. We spoke to Mr. Mogotsi. He said that he's delayed in traffic, but his GPS shows him that he'll be here in the next 15 or 18 minutes. I'm uncertain how the Commissioners would like us to deal with the matter. Do we proceed in absentia or do we wait for him to arrive? I seek the Chairperson's direction.
To my mind, this is very much akin to a motion matter in court. You don't need the litigant in such a matter. So let's start.
Thank you, Chair. Co-Commissioners, this is an application that is being brought by Mr. WritingBrown Mogotsi for the recusal of Matthew Chaskalson SC, who is the chief evidence leader in the proceedings where Mr. Mogotsi is witness. Now, Chair, what the relief that the applicant seeks is that Advocate Chaskalson be recused from the matter and an alternative evidence leader be appointed to cross-examine Mr. Mogotsi. The basis of the application rests on the possibility of biasness or impartiality. And this, Chair, stems from
Actual bias or actual bias alternatively perceived?
Perceived bias, Chair.
Not actual, but perceived.
Perceived bias.
Thank you.
Chair. And the reason for this perceived bias is as a result of events that took place before the Commission on the 9th of March and the 10th of March. Mr. Carrim Suleiman came in to bear testimony before the Commission. Now, during the said days when Mr. Suleiman was giving testimony, there was communication between the evidence leader and Mr. Mogotsi, who's the applicant for the recusal. That communication comes in the form of WhatsApps.
I think there is an antecedent question, a legal question, because how we grapple with the events that you referred to depends on what the law is. Because you must first know what the law is, and then you apply the law to what you've referred to as the events, which effectively are facts or factual issues. In your application, you rely on SARFU and other cases. Those cases relate to situations that involve decision makers in whatever form those may manifest. The respondents have taken the point that those cases are irrelevant to a situation like the present, where a decision maker is not involved. And the point made is that the chief evidence leader is not a decision maker. So what law are you relying on? Because the point is correct that the cases that you've referred to in your application relate to decision makers. So are you continuing to rely on those cases? If so, on what basis would they be applicable here?
Chair, I would be inclined to concede that the cases or the case law that was used by the applicant is that of the decision makers and not the parties who partake in the proceedings. But then from that, Chair, I will also submit to the Commission that case law has been brought to the attention of the Commission in the form of an answering affidavit by the respondent. And the cases that are therein mentioned do make provisions for instances where prosecutors and, with this case, an evidence leader may be recused from certain proceedings.
Can you state the principles insofar as you see them, and for us to have an idea of the case you want to make out?
Chair, there's